So we plus bullshit. Because you were renting beyond. Correct. So this is your own place, lah. No, I got just a champion over there, bro. Yeah, you can just chill. Yeah. Wait.
Oh, we're flying on the 9th, it starts on 10.
Bro, this beyond 10. We're flying in 2 weeks and it's beyond 10. Oh, yeah. Everybody following us, because we want to send PR. Now Daniel say everybody send in PR. There's no champions, I'm not. Yeah, I say. So overdue, but 2 weeks, you would have 7 more. Thinking on right, yeah.
3 per week, then 1 day.
Yeah, I'm playing 3 per week. Okay. Okay, I think we can start.
Good morning, Mr. President and members of the tribunal. My name is Abby Pham, and together with me is Ms. Natalie Tan. We'll be taking the case for the respondent. Our opposing counsel are Mr. Abhishek Behera and Mr. Lee Kiran, representing the claimant. The parties have agreed, subject to the tribunal approval, that the claimant will start first on issue 5 and 8, while the respondent will start first on issue 4 and 9. The rebuttal and sur-rebuttal will be submitted after each party have finished their own submissions on each issue. We will speak for 9 minutes on each issue, reserving 1 minute for rebuttal. Would the tribunal agree to the arrangement? For issue 4, the US had imposed export bans and legislations to take back the gold from the investors. The claimant is now seeking compensations from the US for the taking of gold.
Sorry, Ms. Pham, have we officially started submissions?
Yes.
Given that issue 9 is very much a live issue, do the parties agree that issue 9 should actually be raised first? Given that it concerns whether one of the members of the arbitral tribunal should actually be sitting here to be hearing these disputes. It seems rather strange to be jumping into issue 4. Would both sides agree?
The respondent is agreeable to it.
The claimant is agreeable, I suppose.
Very well. Let's proceed with issue 9 instead then. Thank you.
Good morning, members of the tribunal. As earlier introduced, I am Natalie Tan. I'll be taking the respondent's case for issues 9. It is our position that Chairman Olano should be disqualified due to justifiable doubts of his impartiality and independence in the arbitration. To this end, we provide 2 reasons. First, the relationship between Mr. Fielding and Chairman Olano creates an appearance of impropriety. Second, the failure to disclose any relationship between Chairman Olano and Mr. Fielding on the part of the claimant's counsel allows us to disqualify the chairman. Pursuant to Article 20 of the VIAC rules, an arbitrator can be disqualified if the circumstances give rise to justifiable doubts as to his impartiality and independence. Pursuant to General Standard 2 of the IBA Guidelines on Conflict of Interest, doubts are justifiable if a reasonable third person, having knowledge of the relevant facts and circumstances, would reach the conclusion that there is a likelihood that the arbitrator...
What's the relevance of the IBA standards in relation to the VIAC standards?
The IBA standards has been used by multiple exit tribunals as guidance on whether the arbitrator can be disqualified and gives further explanation as to what justifiable doubts in the VIAC rules mean.
Do we have any precedent where the IBA rules have been applied to interpret particular articles of the VIAC?
The 2008 Exit Tribunal of HEP and Slovenia has relied on the IBA guidelines.
And did that particular decision concern the VIAC rules or the Vienna Investment Arbitration rules?
It did not rely directly on the VIAC rules, as the VIAC rules is still relatively new and there has been sparse case law on the VIAC rules.
So why should we be relying on the IBA rules in respect of interpreting Article 20?
The exit tribunals have relied on the IBA rules with reference to the UNCITRAL rules, and if we read the reading of the VIAC rules, they are very closely in line with the UNCITRAL rules. We can draw the analogy to apply the IBA rules as guidance to justifiable doubts of the arbitrator.
Okay, thank you.
According to General 2 of the IBA guidelines, there is a very low threshold to be met, as all that is required is the mere existence of a likelihood. The explanation to the General Standard 2 of the IBA guidelines states that the test is merely an appearance of justifiable doubts as to the impartiality or independence of the arbitrator. And this brings me to my first submission on the relationship between Mr. Fielding and Chairman Olano. Mr. Fielding and Chairman Olano had a working relationship that exposed Mr. Fielding to confidential information of the case. And this can be found on the record at paragraph 66, where the resume of Mr. Fielding states that he helped with case review, legal research, and procedural correspondence with relevance to the present arbitration. Given that Mr. Fielding is now working in the claimant counsel's firm, the existing relationship between Mr. Fielding and Chairman Olano results in his existence of the likelihood that Chairman Olano may be influenced by factors other than the merits of the case.
What date is it today, Counsel?
This arbitration is taking place in 1942.
Okay, thank you.
In our present case, there is an appearance of impropriety due to the prior relationship. Mr. Fielding, as earlier mentioned, was involved directly with the case and the substantive issues. This is because the time period where Mr. Fielding was training under Chairman Olano directly coincides with the period of time where the claimant filed their observations. The time frame that Mr. Fielding was training under Mr. Olano can be seen from paragraph 66, April 1941 to September 1941. And if we refer to paragraphs 59 to 62 of the record, we can see that the timeline directly coincides, and this would mean that Mr. Fielding had access to the claimant's case. Although Chairman Olano claims that he only worked on extract points of law with Mr. Fielding at paragraph 68 of the record, this does not detract from the fact that Mr. Fielding had access to the case. This means that Mr. Fielding was privy to the confidential information. Having had worked personally with Chairman Olano, Mr. Fielding now being in the claimant's counsel's office results in the potential disclosure of the confidential information that he was privy to. This results in this existence of the likelihood that information from Chairman Olano could have passed on to the claimant, and they would be able to use it to their own benefit. This creates the potential to influence the deliberative process of Chairman Olano with factors other than the merits of the case.
So how do you deal with the point, Ms. Tan, about how the fact that he only touched on legal points and was not even aware that he was actually researching this arbitration?
Well, to that, we first say that it is the chairman's word against Mr. Fielding's word. From Mr. Fielding's point of view, he did work directly on the case. And further, it's not whether there is actual breach, but rather there is this appearance of impropriety. And even though he may not have worked substantively on the case, it is a fact that he did work on the case. And this could still result in this appearance of impropriety due to a potential conflict of interest.
Sorry, to clarify, did he work on the case or on legal research relevant to the case? And could you direct me to specifically where on the record?
On the record, it does state that he worked with Mr. Chairman Olano with legal research relevant to the case. However, the fact that he was privy to what the case was about, and it was at the same time when the claimant filed their observations, this would mean that he could have access to the information of the case. But even if the tribunal is not with me on the point that he had access to the case, my second submission brings me to the claimant's counsel's failure to disclose the relationship between Mr. Fielding and Chairman Olano, and this results in the appearance of impropriety. Under General 7A of the IBA guidelines, counsels are under the duty to disclose any relationship between the arbitrator and members of their firm. It is specified that the party should do so on its own initiative and at the earliest opportunity. However, the claimant's counsel failed to disclose this prior relationship between Chairman Olano and Mr. Fielding, even though they were well aware of that very fact. This was clearly identifiable from Mr. Fielding's resume at paragraph 66. The claimant's counsel ought to have known the relationship between Mr. Fielding and Chairman Olano, and it was their duty to disclose.
Counsel, sorry, but Chairman Onano is a very big time lawyer. He has come across many people during his time. And Mr. Fielding was a trainee in his team, and it's normal for him to, for a lawyer at Mr. Olano's level to perhaps miss out Mr. Fielding. Can we really make too much out of this fact that he forget to mention Mr. Fielding and this prior, very, I would say, superficial relationship that they had?
Well, to that we say that it is not the case on the record, because at paragraph 68 we see that Chairman Olano was, he employed a team of only 3 full-time lawyers and nearly 3 to 4 trainees. It's very hard for him to miss out on the presence of Mr. Fielding in his firm. And we note that it is not practical or to expect Chairman Olano to know where Mr. Fielding proceeds on after his traineeship. However, under the General Standard 7A of the IBA guidelines, the duty is on the claimant's counsel to disclose and not Chairman Olano.
If there's this duty of disclosure, what's the normal course of action for breach of this duty of disclosure? Is it always necessarily the removal of an arbitrator? Or is it just a best practice guidelines recommendation?
Under the IBA guidelines, the breach of the duty would result in the disqualification of the arbitrator, and this would be with the rationale to ensure that there is no conflict of interest and also to ensure that there is a fair and impartial hearing. I note that my time has elapsed. If I may have 30 seconds to just wrap up my submissions. Due to the failure of the claimant's counsel to disclose this fact, this leads us to justifiable doubts as to the relationship between Chairman Olano and Mr. Fielding. There could have been potential disclosure of information, and because of their failure to disclose, we submit that the chairman should be disqualified. And with that, I conclude my submissions.
A very good morning to Mr. President and members of the tribunal. My name is Kieron Lee, and I will be appearing for the claimant for the next 9 minutes on issue 9, which relates to the respondent's application to recuse Chairman Olano. Now, while we agree with the respondents on the legal test to which an arbitrator may be recused, we disagree on the legal threshold. Now, it is clear from the IBA guidelines that what is required is a likelihood that the arbitrator is influenced by factors other than the merits of this case. But that does not mean that this threshold is a low one. While we recognize that what is required is a likelihood, this likelihood must result in the arbitrator being influenced by factors other than the merits of the case. And this is the crux of our submission today. Now, our submissions are twofold. First, that there is no appearance of partiality because the brief and insignificant acquaintance between Chairman Olano and Mr. Fielding does not show any bias or predisposition towards the claimants. And second, there is no lack of independence because the argument on disclosure does not ipso facto result in there being any lack of independence on Chairman Olano's part. Now we turn to our first submission on the appearance of partiality, or rather that there is none. Now we note that impartiality refers to the absence of bias or predisposition towards any particular party, as stated in the 2006 ICSID decision of Burlington and Ecuador. Now, the degree of familiarity and proximity between the arbitrator and the individual concerned are factors used to determine whether there is this lack of impartiality. And this was stated in the 2023 ICSID decision of Makina and Turkmenistan. Now, members of the tribunal, the respondent alleges that there was a close working relationship between Chairman Olano and Mr. Fielding, but we disagree. Now, Mr. Fielding had a 4-month traineeship with Chairman Olano, which was brief, limited, and impersonal. At paragraph 68 of the record, we see that Chairman Olano had only met Mr. Fielding twice during this stint of 4 months, assigned him abstract research unrelated to the case, with the results being discarded. Now, in our current situation, there is no evidence of any continuing relationship between Chairman Olano and Mr. Fielding. Now, this is in contrast to the 2018 ICSID decision of Big Sky Energy and Kazakhstan. Now, in that case, the tribunal held that the arbitrator was indeed partial because he had close personal ties with 2 Kazakh judges who had participated in domestic decisions at the heart of the dispute. Now, his connection to those judges in that case raised concerns that he may lack objectivity. However, in our present situation, we see a vast difference. Now, Chairman Olano and Mr. Fielding had a very impersonal relationship. In contrast to the case of Big Sky, where the relationship spanned more than 2 years, in our current situation, the relationship was 4 months only. And furthermore, there were only 2 instances where Chairman Olano and Mr. Fielding had any prior meeting. Now, we say in our current situation, there is a weak and speculative link that the respondent tries to make, and there is no reasonable basis for disqualification of Chairman Olano. Now, we then...
Mr. Lee, perhaps you could address us on the point about why Mr. Olano did not see fit to bring this up. Perhaps that could have been avoided we could have avoided the situation that we are in where where the other side is challenging his partiality or the appearance of partiality.
Mr. President, this brings us to our second submission on why the duty to disclose does not, the breach of any duty to disclose does not result in a recusement of Chairman Olano. Now, the respondents allege that Chairman Olano had a duty to disclose the fact that he knew Mr. Fielding. However, we say that Chairman Olano had no knowledge that Mr. Fielding had joined the claimant counsel's firm until the respondent had raised it, and this is supported by the facts. Now, we see that the reason why Mr. Olano would not know of Mr. Fielding's subsequent employment is because they neither had a close or personal relationship. And we note that Mr. President had earlier queried the respondents on this lack of disclosure, and we recognize the practicalities of this situation. We note that Chairman Olano is a big-time lawyer, and it is normal for him to miss out on Mr. Fielding's position given their superficial relationship. And this goes towards our first submission that they did not have a close and personal working relationship. Now, we also note that the respondents had attempted to argue that there is a duty on the claimants to disclose this prior working relationship. However, General Standard 7C of the IBA guidelines only requires for this level of disclosure which pertains to the counsel team of the tribunal. Now, members of the tribunal, we see that my co-counsel is Mr. Abhishek Behera and not Mr. Fielding. Now, Mr. Fielding is not part of the claimant's team in this arbitration. He works in a different office and has no involvement in the present case. And this can be seen at paragraph 67 of the record. Therefore, no duty arose here to disclose Mr. Fielding's name because the obligation only extends to lawyers that are actively involved in this present proceeding. Now, had Mr. Fielding been directly assigned to this case, we would accept that disclosure was appropriate. But given the present situation, we say that the respondent's arguments do not fly. Now, even if the claimant's counsel had a duty to disclose under General 7 of the IBA guidelines, we go one step further to say that this does not affect the chairman's independence. Now, this is because the duty to disclose is separate from the test under Article 20 of the VIAC, which the respondents also rely upon. Now, the key test there is whether a reasonable third party would find a lack of independence or impartiality, and we say that the lack of any disclosure does not ipso facto lead to that conclusion. Now, we see General Standard 3G of the IBA guidelines, in fact, and it states there that an arbitrator's failure to disclose certain facts and circumstances does not necessarily mean that a conflict exists or that a disqualification should ensue. And therefore, we see that it is clear from the IBA guidelines that even if this tribunal were to accept that there was a duty to disclose and that this duty was breached, this does not result in the recusal of Chairman Olano as the respondents allege. And unless I may be of any further assistance to the tribunal, this will conclude the claimant's case on issue 9. Thank you.
Members of the tribunal, to clarify, the claimant has tried to allege that my submission was there was a duty on the chairman to disclose. However, I did not make that submission and I claim that the duty to disclose was on the claimant. Further, the claimant has relied on the IBA guidelines to say that there has to be an objective standard, that there's a lack of impartiality or independence. However, he omitted the word the likelihood of. And this is important because as held in the 2008 ICSID HEP versus and Slovenia case at paragraph 15, the tribunal held that the objection is not any actual lack of independence or impartiality, but the apprehension of the appearance of impropriety. And this is seen on our facts. We have to ensure that there is procedural fairness, and the claimant's failure to disclose did not give the respondent any assurance that there was indeed independence and impartiality. And this concludes my rebuttal.
Members of the tribunal, 2 points in rebuttal. First, the claimants did deal with the duty to disclose on the part of the claimants. We did not only talk about Chairman Olano's duty. And second, the respondents may have been mistaken that the claimants have omitted the usage of likelihood under the threshold. Now, this is something we recognize. However, we say that threshold is not as low as the respondents allege because the likelihood must result in the arbitrator being influenced by factors external to the merits of the case. Now, this concludes the case for the claimants on issue 9. Thank you.
If the tribunal has no further instruction, we will now proceed with issue 4. For issue 4, the US has imposed export bans and legislations to take back the gold from the investor. The claimant is now seeking compensations from the respondent for the taking of gold, and it is the respondent case that the claimant does not have a claim in compensations because the respondent has legitimately exercised his police power. Here we have two submissions. Firstly, the respondent can exercise its police power doctrine, and secondly, the police power doctrine was exercised legitimately. Preliminary, we understand that the police power doctrines provide that state possess an inherent right to regulate in protections of public interest and does not act wrongfully when, pursuant to this power, it acts bona fide, non-discriminatory, and proportionate regulations in accordance with due process. This was recognized in the 2023 Permanent Court of Arbitration case of DTEK and Russia. To show that the respondent can exercise this doctrine, we argue that this doctrine was accepted as customary international law, and the BID did not prevent its exercise. So firstly, it is the claimant positions that the police power is not customary international law because it's a mere minority theory. However, this is not the case because the police power doctrine is customary law and it has both general practice and acceptance that practice is the law, which is opinio juris. This is according to the standards of the 1969 ICJ reports of North Sea continental shelf. So here we can see that the state practice can be established because there is consistent and general practice by states. The police power doctrine has been incorporated to various states' agreements and treaties, namely the US Model BI.
Wouldn't the fact that it is incorporated in some treaties and explicitly left out in others suggest that it is not a principle of customary international law, but rather a creature of treaty?
Here we can see that the state practice can be represented to the fact that the state actually accepted that police power doctrine is one of the acceptable practice, and following that line of logic that Ms. Wee has mentioned, we can argue that in this BID, there actually police power doctrine being incorporated,
Under the public interest.
which is Article 2.2 in the BID. This would be in page 2 of the BID, Article 2.2, which mentions that this agreement shall not affect the right of the contract parties to regulate within their territories. So this would be the manifestations of police power doctrines, because the state will have an inherent right to regulate within their own territory. And
Wait, sorry, but the wording in Article 2 says, shall not affect the right of contracting parties. It just means that if the right exists, it doesn't affect it, but it doesn't recognize that the right necessarily exists, right?
here it said that shall not affect the right of the contract party to regulate. So there is an expression that say that there is recognizing that there is a right to regulate by the contracting party.
You're using Article 2 to read Article 4 of the BID, is that correct?
Article 2.2 would be a general recognition that the police power doctrine is being manifested and can be read in the BID. This would not be any way in relation to Article 4. However, the claimant may argue that Article 4 is a lex specialis case and can be more specified in these situations of expropriations. And to that we reply that in Article 2.2 is actually explicitly mentions that the provisions of the agreement shall not affect the right. Henceforth, it means that any provisions thereafterward will not affect this right to regulate by the contracting parties. And however, there might be a dispute over whether or not this measure was necessary to achieve the objective, which is also mentioned in Article 2.2. That the regulations power must be necessary to achieve the legitimate policy objective.
Actually, I'm just curious, why are you relying on this police powers doctrine when under Article 4 itself, it allows you to take a measure in public interest? What's the difference?
The difference in police power doctrine is that there is no requirement of compensations, and the elements of police power doctrine is public interest, due process, non-discriminative manner. However, there is another element which is proportionate measure, meaning that the policy measure must be proportionate to the policy objective that being achieved.
Are you then choosing a doctrine with a higher standard of proof on your part?
We are not picking and choosing doctrine here, and we are merely reading the Article 22 in relations to the customary international law. And we're reading this in accordance to the police power doctrine that exists in customary international law.
Sorry, Ms. Pham, I think Ms. Wee's question was more of, are you putting yourself to a higher standard by choosing to submit on the police power rather than the power to act in the public interest? And if so, why? I think that's, we want to understand where the submission is going.
Essentially, the respondent claim is to not have any more compensations being made to the claimant. If we are to act according to Article 4.4, we would have to comply with Article 4.1, subsection B, which say that there must be compensations given to the claimants.
But then you'll be conceding that the compensation you gave compensation, right? There is a compensation.
We are arguing that the value of 1.25 payment is merely a regulatory measure. So essentially, this payment is a statutory conversion mechanism because our regulatory measure is a forced exchange of gold coins with US dollar. So there is no further compensation being made.
But is it in itself already compensation? Because then I would be wondering whether or not you are conceding that whatever compensation is not adequate compensation. That's why you don't want to rely on this article, because you don't want to get into Article 4.1d.
Firstly, we argue that there was no compensation being made because the compensation value would likely to involve some form of valuation process that accounts for the investor economic suffering. However, this amount payment here is merely reflecting a statutory regulated fixed exchange rate that would not be reflecting of compensation's value.
Okay,
And
alright.
moving back to my submissions, we argue that this measure was necessarily needed to combat the aftermath of the Great Depressions, because here our policy objective is to achieve economic stabilizations and monetary control to revive the US market. And the fact that we need to achieve this is the step that we can do to achieve this is to abandon the gold standards, and therefore the gold reserve would replace the gold standard with fiat money as currency, allowing the Federal Reserve to issue currency based on its own credit instead of based on a gold standard. And this is necessary and effective because alternative would be to still rely on the gold standard or other standards that will still render the US economy subject to the current deflations and financial crisis. And seeing that my time is about to elapse, I will have a 1 minute summarize of my second submissions. And we put forward that there has been a legitimate public purpose when exercising police power to protect the US monetary and financial systems that was done through the due process of law with sufficient independent judicial review in a non-discriminatory manner because the legislations affected all investors and not just the claimant alone. Lastly, we argue that the measure is proportional because the gains when reviving the economy and bringing the US market out of the devastating aftermath of the Great Depressions would outweigh the economic loss suffered by the claimant. If the tribunal has no further questions, this would conclude the submissions from the respondent.
Good morning, Mr. President and members of the tribunal. Now I continue on the case for the claimants on issue 4, which centers around whether the respondent is obliged to provide compensation when it decided to take away our gold coins. And here it has relied on the invocation of the police power doctrine to say that it is justified in taking the gold coins without providing compensation. However, we disagree. It is our case today that the respondent is indeed obligated to provide compensation, and we provide 3 reasons for this. The first, the police powers doctrine is not part of customary international law as it lacks consistent state practice. Second, if police powers is recognized, we say that the regulatory measures that resulted in the US taking away the gold coins is an expropriation, and that justifies compensation under Article 4.1 of the BIT. Last, and in any event, there was a breach of legitimate expectations by the United States, and that resulted in the United States not being able to rely on the police power doctrine. And before I turn to my first submission, Ms. Reed queried the respondent as to whether there was compensation in the present case, and to that the respondent has said no, because they justified the offerance of 1.25 million as merely a regulatory measure. However, we would disagree with that, and we would say that there was indeed compensation provided by the respondent, and that harms the case. Now, as seen from paragraph 32 of the record, that first made an offer to compensate at US dollar 1.2.
Sorry, you want to slow down to take us to paragraph 32 of the record?
Yes. That will be at page 8, members of the tribunal.
Yep.
So at page 8, we see after the respondent had applied to earmark the gold coins within the United States, it denied such a request, and therefore after that, it had provided an offer to compensate at US $1.25 million. Now at page 11, members of the tribunal, at paragraph 49, it is seen that later in 28 August 1939, the US finally made a payment of US dollar 1.25 million. Therefore, it is inconsistent for the respondent to maintain the argument that there was no compensation provided, as it in of itself had recognized that there was some duty to compensate, otherwise it would have provided no compensation in the first place. Now, I will go to my...
Sorry to interrupt you, Mr. Vera, but I think Ms. Wang's point was that this is not what they would call compensation. Rather, the word that she used was a statutory
measure.
It's a statutory measure that resulted in some conversion of funds that was paid out. It's very different from compensation, which suggests wrongdoing on the US part. So how would you address this?
Well, Mr. President, we recognize the characterization of respondent to say that the offer of 1.25 million was simply a statutory monetary payment provided by them. But we say that is ultimately a form of compensation because such statutory payment was based on the inherent value of gold set at the moment when the US gold coins were sought to be expropriated. And given that was the value of the gold coins, it shows that there is an obligation that is understood by them that they have to return the gold coins at the value of the gold, which was 1.25 million. That being said, we say that the respondent cannot rely on the police powers doctrine because ultimately it is not part of customary international law. Now, for there to be consistent state practice,
I think the respondent ultimately didn't actually argue about it being customary international law. They said that it's founded on Article 2 of the BIT and therefore it's treaty, not custom.
Missy, we recognize that and we indeed agree that they have sought to rely on Article 2.2, but we understand that it also sought to rely on the police power doctrine to show that it is enshrined under Article 2.2. Therefore, we say that even if we take the respondent's case to the highest and say Article 2.2 is indeed taken, we submit that ultimately Article 2.2 cannot be relied upon to justify taking the gold without providing compensation. Now, we say that Article 2.2 only shields regulatory measures by not making the state liable for implementing laws or executive orders that is required to maintain the public interest, and in this case, the Great Depression. But it does not go so far as to shield the respondent state for measures that cross the threshold into depriving the investor of ownership or control of the investment. It only allows them to implement such laws that are necessary. Therefore, we say that when such regulatory measures deprive the investor of such investment, Article 4.1 applies then. And this means there must be a line drawn between a regulatory measure and the moment it crosses into the realm of expropriation. And this was also recognized in the 2019 exit decision of Hydro Beceti and Albania No. 1. Now, we say that such a line is drawn where the regulatory measure enters into the realm of expropriation, and this entails that there is a deprivation of ownership over the control of the investment. And we say that such a line is justified because ultimately, when a regulation is imposed and that regulation simply damages the investment or results in the loss of profits of the investment, we would accept and agree that in such scenario, compensation is not required. And it is because states are just invoking the right of police powers doctrine. However, when such a police power doctrine results in the investor losing ownership and control of the investment, we say that there is an expropriation. And in such a case, expropriation is essential to uphold the rule of law and the protections enshrined under the BIT
Isn't
because
it quite artificial to draw a distinction between whether or not I'm completely deprived of profits versus losing control? Because at the end of the day, what's investment for, right? An investment is for return of profits. So isn't it just as devastating to me as an investor that I basically return nothing due to the actions of the state?
Well, Mr. Liu, just to clarify our position, we say that if there was no profits that arises from as a result of the regulatory measures, then we would say that it's indeed a deprivation. But if there is a loss in profits and that profits has been reduced, then we would accept that the state would not be justified in providing compensation because ultimately such regulatory measures are part of the risk. But when the regulatory measures in of itself does not even allow the claimant's investor to even earn potential profits, we would say then in such a case it is an expropriation and Article 4.1 is relevant. Therefore, when Uber
Sorry, just for clarification, if they are completely deprived of control and ownership, but they are given adequate compensation, is that still called expropriation?
we will say if adequate compensation is provided, then they will be justified in providing expropriating the gold
So
coins.
expropriation is completely independent. The assessment of whether or not investment has been expropriated in the claimant's view is independent completely of whether or not compensation is provided, regardless of how adequate or, well, appropriate the compensation is.
We will say that ultimately, we will say yes, Mr. Liu, because ultimately there is expropriation, but then the question would turn into whether there was lawful or unlawful expropriation, which turns towards issue 6, which is not before this tribunal to date.
Sure.
Now, having said that, we submit that ultimately, given such a line is drawn, we say that their actions falls into the realm of expropriation, and therefore under Article 4.1, they are justified and obligated to provide compensation. Now, ultimately, even if the tribunal takes a position that they're indeed justified in providing, in using the police powers doctrine to expropriate and take away our gold coins, we say that they cannot rely on this doctrine because there was a breach of legitimate expectations. Now, in the 2005 UNCITRAL decision of Methanex and USA, it was noted that non-discriminatory regulations for a public purpose is justified and does not require for the respondent to provide compensation unless specific commitments had been given by them that such regulatory measures would not apply to them. And therefore, in the present case, and as seen from paragraph 23 at page 5 of the record, the acting secretary of the Treasury clarified that Executive Order 6102, which required investors to return the gold coins and they be compensated, did not apply to foreign investors. However, on 18 April 1934, which is seen at paragraph 28 at page 7, when it had again applied to earmark the whole gold coins to be held in custody for the bank account in Switzerland, the state not only denied the request but further demanded that such gold coins be returned. And therefore, we say that ultimately US had made a representation that they would not be required to return the gold coins, but later on resolved from such a representation and then requested the respondent to return those gold coins. And therefore, following the 2005 UNCITRAL decision of Methanex and USA, we will say that when there is a breach of such legitimate expectations, they are not allowed to take the gold coins without providing compensation. I note my time.
Just to clarify real quick, in the Methanex case, was there a clause that read that legitimate expectations or arbitrary deprivation wasn't to be provided for? I'm just asking because right now Article 4 seems to be quite exhaustive. It's got an and it seems to list out the requirements or the conditions. So, yeah.
Ms. Wee, I note my time. If I may answer questions, then run down my submissions. Now, we do not have the particular provision that the 2005 UNCITRAL decision of Methanex and USA relied on, but we will say that it's not detrimental to our case today because ultimately such a recognition of legitimate expectations is not only relevant to that particular case, but it's also seen in the UNCITRAL decision of Saluka and Czech Republic. And ultimately, we say that such a requirement for breach of legitimate expectation to deny the use of police powers doctrine is indeed justified on the present case. Now, unless I may be of further assistance to this tribunal, this concludes my submission.
Members of the tribunal, the claimant seeks to argue that there was legitimate expectations and hence it was on this respondent to pay the compensations as stated in Article 4. However, as we have queried the claimants that whether or not legitimate expectations should be recognized as an element in Article 4 or should be recognized as a customary international law. However, firstly, we argue that there is no mentions of legitimate expectations in the BID anywhere in the BID, nor has there been any legitimate expectations being recognized by the CIL because the claimant failed to prove those points. And secondly, even if legitimate expectations is an element, there has been no breach because the US government did not make any representations that there has been no requirement for there has been a ban on hoarding for the foreign investor because the one who making the representation is merely an acting secretary of the treasury, not the government himself, and nor has it been the representations of the law. And the representations and the law as it stands would be seen in the judgment being handed by the Court of Appeal in the record page 9, paragraph 38 and 39, which mentions that as though our financial system was imperil, this was hardly seen why the legislation should be enacted and would not be applied to the non-residents.
Just to clarify, are you saying that the acting secretary of the Treasury, in paragraph 23 of the record, is not speaking on behalf of the US government?
The acting secretary of the Treasury would not be able to make legal representations or legal readings of the law, and the only one who can make the legal readings and legal interpretations of the law would be in the domestic court, which can be seen by the US Court of Appeal judgment in page 9, paragraph 38.
So what's the authority for saying that an acting Treasury Secretary cannot speak with binding force upon the state?
We do not have a case law to show that the acting secretary cannot represent the U.S. government. However, we here arguing that the acting secretary here will only work in relations in this specific and the acting secretary specifically answer to the president proclamations and specifically interpreting these president proclamations which is handed down before the Gold Reserve Act. So the acting secretary representation would not be an interpretation of the Gold Reserve Act.
Doesn't that lead to a very weird situation where the only arm of government of state that can make representations becomes its judges and judiciary? So the head of state, the prime minister, the president, the senior minister, minister mentor, senior minister mentor, emeritus, none of them can actually make representations on behalf of the state because they're not part of the judiciary?
If the tribunal is not with us on this point, we then seeks to argue that the Gold Reserve Act was enacted after the president's proclamations, and hence it will be able to review the representations made previously by the president's proclamations. Seeing that my time is up, if I may be of further assistance to the tribunal, this would conclude the submission by the respondent.
Members of the tribunal, 2 points in rebuttal. Now, earlier the tribunal questioned the respondent as to whether can it truly be said that the acting secretary is not part of the United States. And to that we say that it cannot be the case because if the acting secretary cannot give representations on behalf of the United States, we cannot say that there might be any other body who might be able to make such representations on part of the Federal Reserve, which is precisely an organ of the United States government. And therefore we say that such an argument provided by the respondents simply does not stand. Now, our second point of rebuttal simply goes on to state that the respondent claims that the requirement of legitimate expectations is not part of Article 4.1 and therefore it cannot be relied upon. But our argument is that the requirement of legitimate expectations is part of the police powers doctrine. And if their claim is that they rely on the police powers doctrine to justify expropriation based on customary international law, we would say that if the tribunal recognizes the doctrine of police power doctrine under customary international law, it should also recognize this requirement that a breach of legitimate expectations does not justify the state to use police powers doctrine. Not unless I may be further assistance to this tribunal, this concludes my submission.
Is it 5 or 8 first?
Mr. President, we'll start with issue 5, then we will go to issue 8. If I may begin, members of the tribunal. To start off, issue 5 simply concerns the material scope of the umbrella clause under Article 5.2 of the BIT. Now, the aim of such umbrella clauses is to simply improve the protection accorded to investors under the BIT, and it does so by providing that host states are indeed obligated to observe obligations that they have entered into with the investments, and this was recognized in the 2005 exit decision of Yoko and Poland. Therefore, the issue before this tribunal and what it must determine is that whether the obligations by the US to compensate the claimant under $35 per ounce falls under this very umbrella clause, and therefore whether it was unlawful for the respondent to compensate at $20.67 per ounce. And we submit that it was indeed unlawful. And I make two submissions in relation to this. The first, the US legislative and executive acts in relation to the gold coins, which mandated the gold coins to be compensated at $35 per ounce, do fall under the part of the umbrella clauses and are elevated the treaty obligations. And second, even if the legislative and executive acts are not elevated to treaty obligations, it was arbitrary to compensate the claimant at the former price of $20.67 per ounce. And with that, I turn to my first submission. It is our position today that umbrella clause under Article 5.2 of the BIT elevates, and I quote, any obligation between the state and investor to a treaty obligation. Therefore, the obligations arising from legislative and executive orders such as the Gold Reserve Act and the Presidential Proclamation number 2072 are indeed treaty obligations. Now here the respondent may seek to argue that general legislation and executive acts are not elevated to treaty obligations and are simply limited to specific individual obligations, such as to contractual obligations that are allowed to be elevated to a treaty obligation. Here, we will not dispute with the respondents that contractual obligations can indeed be elevated to treaty obligations, but it's our position that the umbrella clause is much more broader than that, and we say that it would elevate legislative and executive orders as well. And to interpret Article 5.2, we rely on Article 31.1 of the VCLT, which says that the treaty or the provision in question must be interpreted in good faith in accordance with its ordinary meaning. Now, interpreting the phrase shall observe any obligation it has entered into, we submit that the term any obligation refers to all forms of obligation regardless of the source of such obligations, and this was recognized.
Sorry, I'm just curious. The keyword that I'm picking up on is the word observe. What does it mean to observe an obligation? It's not as strong as saying comply with an obligation.
You will say that ultimately observe, in the present case, observe essentially means that the state recognizes such an obligation, and therefore if it chooses not to follow such an obligation, it would not be observing said regulation. And therefore, we say that ultimately any obligations in the present case refers to all forms of obligations, regardless of where that obligation arises from. However, that is not to say that any general obligations under the legislation or executive orders fall under the scope of the umbrella clause. We accept and we recognize that such an obligation must at least relate to the defined group of investors or the investments of the investors as defined within the BIT, and this is also in line with the 2006 exit decision of LG&E in Argentina.
And in that case, what was the phrasing of the umbrella clause?
In that question, the phrasing of the umbrella clause was exactly the same, because ultimately the clause in that case was Article 10.1 of the Energy Charter Treaty. And in this regard, it has been noted not only by this case but numerous other tribunals that Article 10.1 of the Energy Charter Treaty is indeed a broad clause, and it encompasses obligations regardless of the nature. And this was also supported by the 2022 exit decision of Renege and Spain.
And do any of these precedents show an umbrella clause essentially applying to legislation or executive orders?
Yes, Mr. President, it does, because in
Wrong person. Mr. President's over there.
Apologies,
Yeah.
Mr. Liu. In the case of LG&E International and Argentina, the particular legislation in question was a renegation of such abrogation of tariffs that was promised to the investors. Because ultimately, in that particular situation, there was an economic crisis that was going on, and Argentina has sought to abrogate from its promise that it would not apply the legislative tariffs to investors, because ultimately those tariffs were required to be implemented to allow Argentina to recover from its economic state.
So it was essentially a law passed in relation to the tariffs.
Yes, that's
Okay.
right. And therefore we say that the phrase any obligations naturally includes a commitment by a state through laws or regulations and not just contracts.
Sorry, again, you were saying that the wording of Article 5.2 is the same as in the Energy Charter Treaty. Which provision of the Energy Charter?
10.1. But we say that ultimately, if treaty and legislative obligations are not elevated to treaty obligations, it creates a loophole for the state, because ultimately states could simply evade treaty obligations by codifying such practices that may harm investors, and ultimately, if that was allowed, it would undermine the very purpose of the BIT, which was to accord.
Isn't the obvious solution for investors or vehicle investments to simply ensure that they enter into contractual obligations with the state?
Yes, Mr. Lee, we would agree that that would be the best case scenario, but we would say that ultimately importance should be given to the legislation, because that provides the very crux upon which obligations arise to every investor entering into the state. And therefore,
Sure, but I'm still struggling with the actual wording, the plain meaning, right? I mean, you did rely on Article 31 of the VCLT, but the VCLT also gives primacy to the plain reading of the treaty provision. And here it says, obligations it has entered into with an investor. Now, it's very strange to say that a law is passed or an executive order is passed with an investor, right? I mean, if the state of, I don't know, Indonesia suddenly passes a law, and I can't say that it has an obligation with me as a non-Indonesian national. They're just very strange. So how do we grapple with that in light of the VCLT?
well, Mr. Liu, we will not go so far as to say that the law in of itself is elevated to treaty obligations, but the obligations arising from the law towards the investor as defined in the BIT results in an obligation that is elevated to a treaty obligation. Therefore, in the example provided by Mr. Liu, where an Indonesian law is, let's say Indonesia enters into the BIT with Singapore, and an Indonesian law applies that is also relevant to Singapore investors, then in that case, we would say that such an Indonesian law is elevated to a treaty obligation.
I'm almost convinced, Council, but you're still missing one part, which is with an investor. At the end of the day, you can say that Indonesia owes me an obligation, sure, but has it entered into an obligation with me as a result of that law being passed?
Now, to further convince Mr. Liu of our arguments, we would perhaps elucidate this by showing how it is relevant in our present case. Now, over here, we recognize there was a general obligation that was created by the Gold Reserve Act and the Presidential Proclamation that resulted in the United States to compensate investors at $35 per ounce. But we say that this general obligation materialized into a specific obligation with Uberc when Uberc had applied to earmark certain gold coins within its account in the US to be held in custody for its account in Switzerland. And this is seen in paragraph 28 of the record. And therefore, when it was directed to return the gold coins, it was at this very moment that the legal obligation to compensate the gold coins at $35 per ounce became an obligation towards Uberc. And therefore, we say by virtue of the Presidential Proclamation number 2072 and the Gold Reserve Act, the legal obligation that arose from it was directed towards Uberc, and thus was elevated into a treaty obligation.
So to be clear, is it the claimant's position that for such a situation to arise, the state really needs to conduct two steps? The first is to actually pass some sort of act, law, legislation, or order, and then an executive arm perhaps will need to engage in some sort of further action that actually crystallizes this obligation such that it becomes an obligation entered with an investor or the investment? Is that the claimant's position?
Yes, that is indeed our position, because ultimately, and as Mr. Lee also recognized, if a general obligation under law was simply elevated to a treaty obligation, it would be unduly onerous upon the state. Now, unless I may be of further assistance to this tribunal, this concludes my submission on issue 5.
Members of the tribunal, the gist of the issues here is about treaty interpretations, and here we will have two submissions. The umbrella clause in Article 352 applies only to specific obligations undertaken with the investor rather than the US law as a whole. And secondly, even if the tribunal finds otherwise, the respondent has fully complied with all relevant domestic provisions. And given this, the tribunal should defer to the respondent judicial authorities. Moving to my first submissions, the claimant has argued that the Gold Reserve Act and the presidential proclamations created a legal obligations to compensate as $35 per ounce, but it has been elevated to an international obligations. However, there is no such obligations because Article 5.2 is intended for specific obligations and would exclude general legislations, and we employ treaty interpretations method to assess the ambit of Article 5.2. Here, as mentioned by the claimant, we first assess the plain wordings, and the treaty must be interpreted in accordance to its ordinary meanings. So when we read the treaty here, it mentions the phrase "enter into" with the investor, and as queried by Mr. Liu, this should be implying the voluntary and specific commitment by the state, specifically to an investor. And hence, although any obligations can include contractual obligations or obligations assumed through legislations, Article 5.2 limits those obligations to specifically regarding the investor or investment. So here, general legislations and executive acts would not come under 5.2 because they are unilateral and non-specific because they apply to all market factors, not just this particular investor, and they apply to all possessions and usage of gold, not just investment in particular. And we will have some examples of the tribunal practice and how other tribunals have interpreted those umbrella clauses. So in the recent case of 2024 decisions of in Cavis and Italy, the ICSID tribunal dealt with the umbrella clause that worded exactly the same as the one founded in the BIT before us. And when looking at the phrase "to be entered into," the tribunal interpreted it to require an interactions between the state and the investor, so there will be a bilateral legal relationship that gives rise to such an obligations. This is to contrast with the general applicability of unilateral administrative acts adopted by the state, which cannot create an obligations because those general legislative acts would result in unilateral acts performed by the state. And hence, when the measures are adopted unilaterally and applied broadly, there is a lack of interaction with or involvement from the investor, making the obligations fall outside of the ambit of the umbrella clause. And even in the case of 2003 ICSID award of El Paso and Argentina, the phrase "enter into" also imply a consensual obligations arise independently and do not cover the general requirements imposed by the law, because the law will be imposed unilaterally by the state. Contrasting this with the 1984 ICSID award of Enron and Argentina, whereby the phrase was "any obligation regarding the investment," this was being implying a general and broader ambit. These broader interpretations would also include general legislative acts, because the clause did not specifically mention with obligation entered into with the investor or obligation into with the investment of the investor. And even if the claimant argued that the 5.2 can elevate legislative acts that affect investment into treaty obligations, we argue that the Gold Reserve Act and presidential proclamations were not enacted specifically for the investment of gold, but for the possessions and the usage of gold in general. And we have noted that the claimant mentions Article 10.1 of the Energy Charter Treaty. And when we read the ECT Reader Guides, the official commentary, it describes this umbrella clause is intended to elevate the observance of the investor-state contracts into treaty obligations. So when we take a purposive approach, the umbrella clause aims to elevate obligations that were consensual and specific to the investor.
Sorry, Council, was the word contracts used specifically?
The contract was being used specifically in the commentary, not in the treaty itself.
Just to clarify, what are your authorities for number one, referring to all the case law that you have cited, specifically where the wording is similar or where you're comparing the wording? And then what is your authority for referring to the commentaries that support the Energy Charter Treaty in interpreting its wording?
We argue that this tribunal is not binding by previous tribunal decisions or judgment. However, those judgments can give a persuasive reason or can give the tribunal a broader idea how other tribunals have interpreted the similar or exactly the same wording to provide consistent legal applications. And secondly, we take reference to the Energy Charter Treaty because it was also mentioned by the claimant. And secondly, we argue that there should be consistent legal interpretations of treaty across the board.
Sorry, I think Ms. Wee's question was more of what's the authority to rely on the commentary to the ECT. We're not faulting or questioning on the discussion of ECT, but why should we go behind the text of it to look into what the drafters intended? I suppose that's a simple.
We do not have a specific case law or authorities legally binding on the tribunal, but we argue that when taking a persuasive approach, we need to look into the intention of the drafter, and we believe that this phrase was also being lifted in reference with the Energy Charter, and hence we take the reference from the Energy Charter Treaty. And even if this tribunal adopts a different interpretations of Article 5.2, we submit that the tribunal should still defer to the respondent's judicial authorities. This is because in the context of international adjudications, the standard of review must strike an appropriate balance between oversight of compliance with state international obligations and respect for national autonomies in terms of the right to regulate at international law. And this was recognized in the academic text of proportionality and the deference in investor-state arbitrations. So hence, given that the issues of inadequate compensations has been relitigated multiple times and can be seen in record page 8, paragraph 35, it has been relitigated 3 times in domestic court, and we submit that this tribunal should refer to the respondent domestic judicial authorities. This is on the basis that the tribunal should exercise deference where states are called to balance competing interests, as seen in the 2022 Exit Green Energy and Spain. The respondent acknowledged the tribunal jurisdictions but maintains that fiscal policy reasons, especially in time of financial crisis, are a sovereign prerogative. And we submit that deference is warranted to preserve economic stability and respect state discretions in monetary affairs. So in the Exit case, Energy and Spain, as I cited earlier, the tribunal deferred to state domestic authorities regarding policy choice to pursue the public interest of ensuring a sustainability of green energy.
Is there a particular name for this doctrine?
It would be deference doctrine.
Deference doctrine, just deference to domestic law doctrine?
It's a general doctrine that being applied in previous tribunals.
Under what source of international law?
It would be a customary international law.
Okay.
And moving back to my submissions, seeing that my time is elapsed soon, I ask for 1 minute of the tribunal time to wrap up my submissions. Moving back to my submissions, we're seeing that in similar case, the competing interest here involve the claimant economic interest in gold and the public interest in the fiscal stability during the Great Depressions. So the decision to compensate as 20.67 per ounce were not merely a matter of affordability in an isolated case, but a rather necessary policy choice to uphold the integrity of the US monetary system during the period of economic stability. A higher compensations would have set a costly precedent and inviting a wave of similar cases that would impose a substantial financial burden on US Treasury at the time of national crisis. If I may be of further assistance to the tribunal, this would conclude the case for the respondent.
Members of the tribunal, the respondent has sought to argue that an obligation to be elevated to a treaty obligation, such an obligation must be bilateral, and it justified this on the basis that such a bilateral obligation would allow the obligation to interact with the investor. We say that if interaction with the investor is the basis upon how an obligation is characterized, we would say that even unilateral obligations would then be elevated to treaty obligations.
I thought the respondent's case was less on that point, but more on consent on the part of the second party. And then how would you then deal with their interpretation of the BIT based on the ECT and the commentaries to the ECT that require it to be a contract between the state and the investor?
Well, Ms. Wee, we recognize the respondent's arguments also that our obligation to be elevated to a treaty obligation, it requires for there to be a contract, and we also recognize that we've relied on the commentary. But we say that ultimately, if such an interpretation is taken, it will be unduly narrow, because as other tribunals have also interpreted such a provision, we say that such a tribunal decision is more persuasive rather than commentary, because they've understood the evolving background against which investments are taking place, and therefore if these tribunals have recognized for this Article 10 of the Energy Charter Treaty to be elevated to an obligation under the BIT, we will say that it should be recognized. Now, Ms. Wee, I note my time is up. If I may have another minute to make my point. This concludes the claimant submission.
Members of the tribunal, the claimants have argued that there is no need for consents or for contractual obligations to be read into Article 5.2, but there's merely a law that be imposed by the US government. However, when we go back to the plain readings of Article 5.2, we emphasize the phrase enter into with the investor, which also implies that there must be a voluntary aspects on the part of the investor, as well as there must be an interactions between the state and the investor. And when we see the legislative and executive acts here, there is no interactions between both parties, but it's merely a unilateral act imposed by the states for the general applications for all possessions and usage of gold, not just for investment alone. If I may be of further assistance to the tribunal, this would conclude the rebuttal for the respondent.
Mr. President, members of the tribunal, I will now continue the claimant's case, this time on issue 8, which pertains to the document production request. Now, the claimant seeks disclosure of internal analysis created between the dates of 4th March 1933 and 8 May 1935 that explains the respondent's gold price setting process. Now, this is due to multiple newspaper reports that allege that the price setting process was arbitrary. Now, my submissions will be canvassed in two parts. First, on the preliminary argument on the reason for document production, and second, why document production should be allowed by this tribunal, which goes to how it is narrow and specific, and relevant and material. Now, turning to our preliminary argument, now, pursuant to Article 29 of the VIAC rules, this tribunal has the discretion to request parties to submit evidence if it considers it necessary. Now, we could invite the tribunal to turn to page 13 of the record. that would be paragraph 58, page 13. And I quote from line 9. The exercise brought out the juvenile in Roosevelt. One day he picked an increase of 21 cents and when asked why, replied that it was a lucky number, 3 times 7. Now, while the respondent will no doubt dismiss the newspaper articles as mere gossip, the claimant does not rely on these articles to prove its content as fact. Now, rather, it offers a prima facie reason to believe that the price setting process was inconsistent.
Wait, you said you're not going to rely on this, and then you proceed to rely on this to establish a prima facie case? I'm confused.
Now, Mr. Liu, allow me to clarify myself. We do not rely on the articles to prove its content as fact, and therefore we do not need to prove the veracity of what is inside the articles. What we use it for is to engage Article 29. Now, Article 29 is this type of situation is exactly what Article 29 envisions, where the tribunal considers it necessary to order disclosure to test the credibility of a factual assertion that is made.
Well, where in Article 29 does it say to test the blah 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 that you just mentioned? It just says if the tribunal considers it necessary, we can basically do whatever the heck we want in respect of evidence. And if you're telling me, hey, tribunal, some newspaper said 7 times 3 equals 21, quick math, that's pretty cool, right? And because of that, let me request some documents, I'm going to reject it straight out. Surely you have a stronger case than this.
Now, Mr. Liu, this is our case, and this was in fact recognized in the 2009 exit decision of PDF Services and Romania.
Where 3 times 7 was also referenced in that case? Or?
No, Mr. Liu. Now, in that case, it was held that where a factual assertion is made and the respondent or the claimant, one of the parties, wants to test the veracity of that assertion, the tribunal can then rely on Article 29 to ask for the other party to provide evidence to test whether that assertion is true or not.
Indeed, so we can agree on one thing, right, which is Article 29 just broadly sets out the powers of the tribunal under the VIAC rules. But what is exactly the standard? Because I'm seeing the word necessary, and how is it necessary in the tribunal's view, or how is it important enough for us to allow this request for document production on the basis of newspapers that simply quoted an unknown informant? Because isn't this very susceptible to abuse? Don't you need to show a little more than just a newspaper or a bunch of newspapers cited an unknown source? There is essentially nothing. It could be pure speculation, and it might be some might even say it's very easy to fabricate such quotes and deliver them to newspapers anonymously, and then that leads to a large potential for abuse for Article 29. So how do we go from here, counsel?
Just to add on to Mr. Liu's question, Mr. Lee, is this the only evidence on the record that you have for saying that how the price of gold came about was through speculation or questionable means? Is there anything else on the record that you can point us to?
A moment of the tribunal's time.
Sure.
Now, to answer the tribunal's questions, first we will answer Mr. President's query. Now, we do accept that this is the only piece of evidence in the record that casts suspicion on the price setting process by the respondents. However, we say that this does not impact our argument that Article 29 of the VIAC should apply, and this goes towards Mr. Liu's question on the potential for abuse. Now, we do recognize that there is this potential. However, it has been clarified by various other tribunals that Article 29 is a broad power and that it has a low threshold to satisfy. Now, that is because the crux of the issue is to test whether this factual assertion is true or not. Now, the central merits of the case then is on whether the assertion is true, and Article 29 is merely a preliminary threshold that is meant to be crossed.
But I think Mr. Liu's question goes more towards the fact that what we're trying to balance is we need to determine what is factually true, but we also need to balance that against what could be potentially oppressive on the part of the respondent. And while I accept Article 29 will give the tribunal broad powers, the question is not whether the power exists, whether the power should be exercised based solely on one singular source of evidence.
Ms. Lee, we would then point you to paragraph 58 of the record where it says newspapers, and we say that the plural of the newspapers shows that multiple newspapers have come to the same conclusion that the
Of
unknown
course, they
informant
all came. Their source of information was the same unknown informant. Of course, they all came to the same conclusion. You can't ask the same informant and come up with 10 different conclusions, counsel. Come on, you can do better than this.
Tribunal, members of the tribunal, I would then say that this is the highest we can bring our case. If I could have the rest of my time to focus on the substantive limbs of issue 8.
What would that be again? Sorry.
That would be whether the document production request is narrow and specific and relevant and material.
I see. So we will proceed on the basis that you have satisfied, or that we have satisfied ourselves of the threshold to exercise our discretion under Article 29.
Yes, Mr. Liu, much obliged.
Proceed.
Now, in deciding whether to allow document production, the IBA rules on the taking of evidence provides a widely accepted framework. So we see Article 3, which states that a document production request must be narrow and specific and relevant and material. Now, we note that the first limb of narrow and specific pertains to whether the request is reasonably limited in time and subject matter, and this was stated in the 2003 UNCITRAL-NAFTA decision of Thunderbird Gaming and United Mexican States. Now, first we submit that the document production request is limited in time because it was confined to the period between 4th March 1933 and 8 May 1935. Now, this period is not arbitrarily drawn, but directly corresponds to key events in our facts. Now, we see that 4th March had marked the inauguration of President Roosevelt. Now, this radically changed the respondent's economic and monetary policy in response to the Great Depression at paragraph 14. Now, the period between 1933 and 1935 marked the respondent's regulatory framework formation. Now, we saw the enactment of various acts such as the Emergency Banking Act, as well as Executive Order 6102 and Proclamation number 2072, which all fixed the gold price at certain values. And in 8 May 1935, this culminated in the final decision on the respondent's part to deny the claimant's expropriation. Now, I note that my time has elapsed. If I could have 1 minute to finish my argument on this point.
Actually, can I just ask a brief question? Is the test here whether or not the time frame you've provided is objectively narrow, or whether there was a narrower option available that you could have selected but did not select?
The test here is of the former, which is that it must be objectively narrow. And this is satisfied on our facts because we see that the time period circumscribed is one that is relevant to the respondent's price setting process, where the president was first inaugurated, and he is the key party in the respondent state that dealt and directed these policies. And we see that the end also corresponds directly with when the respondent state had made a decision to deny the claimant's export of gold, therefore indirectly expropriating the claimant's investment. Unless I could be of any further assistance to the tribunal, this will conclude the claimant's submissions on issue 8.
Members of the tribunal, I will now be taking you through the respondent's case for issue 8. In this regard, it is our position that the claimant's request for the respondent to produce documents of internal analysis should be rejected, and to this end we make 3 submissions. First, there is no reason for the documentations to be provided. Second, the request is too broad. And third, the matter is neither relevant nor material. Now, the respondent is with the tribunal that the newspaper articles are mere speculation and there is no evidence to prove that fact. It has been held by the International Arbitration Law Review in 2011, the document production, and the 2010 IBA Rules on the Taking of Evidence in International Arbitration, a commentary, at page 7, that discovery of documentation should not be a fishing expedition. The newspaper articles was based on unreliable sources of information, and it is stated in the paragraph itself, at paragraph 58, that no one had a clue how they went about setting the price. And this
In that
means that
case, would that then leave the claimant in an impossible position where they need to prove this fact, or they need more evidence to prove this fact, but they cannot get any more evidence because what you say to be the standard for document production is particularly high? And I think this is relevant for the claimant because other than asking for document production, it's very difficult for them themselves to prove that the president said certain things or had a particular view towards monetary regulation. So in this circumstance, wouldn't it be slightly different?
Well, to that end, we actually say that it is precisely the point why they cannot rely on the newspaper article because it leads to circular reasoning. They need more evidence to prove what is alleged in the newspaper article, and they are using the documents that they're trying to discover to also prove the arbitrary conduct and then substantiate the facts in the newspaper article. Now, if the claimant wants to prove a reason as to why there is a need to discover into such confidential information of the US state, then they should be able to at least produce any sort of alleged arbitrary conduct based on reliable sources. However, that is not.
I guess my question is just what is an alternative reliable source that the claimant can rely on when we're talking about statements made by a president in a private capacity? Because an alternative to this would be a surreptitious recording, illegally obtained evidence that puts them in even more hot water. So wouldn't this approach be the best approach that they can take given the circumstances?
We agree that the circumstances may make it hard for them to try and prove their case, and to that end, we know that the burden is actually on the claimant to prove to a high threshold, as stated in the commentary that I earlier cited, that there's a high burden of proof on the requesting party to show to a large extent why the requested documents are important and crucial to the outcome of the case. And if the reason that they cited is not strong enough, then it is simply their case to give a better reason. And if they can actually prove and identify the source of the information, we would agree that that is sufficient reason. However, they are not able to identify the source. I will now move to the substantive limbs. We say that the claimant's request to produce all internal analysis for the period between 4th March 1933 and 8 May 1935 to determine how the respondent arrived at gold prices is not sufficiently narrow and specific, contrary to Article 33A II of the 2020 IBA Rules on the Taking of Evidence. Following the 2004 ad hoc arbitration decision of International Thunderbird Gaming Corporation and the United Mexican States, this means that the request must be reasonably limited in time and subject matter in view of the nature of the claims and defenses advanced in the case. The claimant's request was simply not reasonably limited in time. The timeframe requested includes periods that was outside of the relevant timeframe to the case. We submit that the relevant time frame of the present dispute starts on 6 July 1933 at paragraph 23 of the record. This was when the expropriation happened, which also marks the dispute between the investor and the US state. Further, the relevant time frame is only until 31st January 1934 at paragraph 26 of the record, where President Roosevelt set the price at 35. This will relate to the claimant's claim that they are entitled to compensation at the price of $35.
Sorry, I think this goes back to the question that I asked the claimant, which is, what is the test? Is the test here whether or not the date they give you is narrow enough, or whether there is a narrower possibility that they failed to select?
Based on the case that I cited earlier, that there must be a reasonably limited period of time, and the facts that I have just substantiated, we submit that the case is that there should be a even narrower time frame that they could have submitted, because they could have asked for the time frame to be between.
So if they do ask for a narrow time frame, then you would be amenable to that.
This would still be
document
subject to the requirement of whether the documents are relevant and material, and on that end we would later submit that the documents are in fact not relevant nor material, and they would still not be allowed to request. Given that the claimant has requested for timeframes outside the relevant time period, we submit that it is not reasonably limited in time and the request cannot be said to be narrow and specific. 4th March
Sorry.
1933.
No, you were just going into 4th March, was it? Okay, please carry on.
4th March 1933 marks the point of President Roosevelt's inauguration. However, we note that at paragraph 14, there was simply no administration or policies that were actually enacted at that point of time yet. It is simply irrelevant to the further policies down the road that were actually enacted, because even at the point of his inauguration, there were no starts of any policies, and this would just simply not be relevant to the
Surely a president's input happens before the policy is enacted, right? You can't just be looking at the specific date the policy enacted, but the period of time before the policy's enactment, because there would surely be a lead up of discussions to the actual enactment of the policy.
We agree that there may be reasons leading up to the enactment of the policies. However, we still submit that since the dispute only started in 6 July 1933, when the expropriation happened, if the expropriation had not happened, any
But I think in this case, we're not contesting, or we're not using this piece of evidence to determine whether or not there was expropriation. We're trying to determine whether the rationale or the reasoning taken by the president in pursuance of what you then say is expropriation was valid or not valid. And that's why maybe events prior to when the dispute actually crystallized would be relevant.
Well, we note that the policies actually encompass things outside of whether the price given to the claimant was related or was arbitrary or not. And if the claimant is only trying to prove the arbitrariness of the price of gold, then the documents requested should only relate to that. And by requesting documents of internal analysis before the dispute happened, this would encompass other reasons as to why the president would have enacted such policy reasons. And even if the tribunal is not with me on this point, we turn to submit that the claimant's request is neither relevant nor material to the outcome of the case. On the issue of relevance, the documents requested must be able to support its contention on an issue. However, the dispute centers around the issue of whether there is a right to compensation or the appropriate time of valuation of the gold. Determining whether or not there is an arbitrary price has no relevance to the determination of those two issues. Further, the documents requested has no influence on the determination of the outcome of the issue and is not material to the outcome.
Is it not material to whether or not adequate compensation was paid? Well, depending on what on earth we count as compensation, because that was clearly in dispute. But assuming that the whole compensation, whether by regulatory mechanism or otherwise, is somewhat a live issue, would you say that the pricing mechanism of gold and in relation to that mechanism of compensation could therefore make it tangentially relevant at best? And what would be the threshold? Would it not be just a prima facie case on the part of the claimant?
Just to add on, I think that doesn't mean it's not an issue in this list of 9 issues stated on the record. Means it's not an issue that's in arbitration, because on the assumption that we are going to proceed with all these preliminary issues and objections, eventually we need to make a decision, and the gold price might become relevant then. So,
I know that my time has elapsed. If I may just answer the tribunal's questions and wrap up. Well, based on the case law that we have, the requirement for materiality actually looks at whether documents will be bearing upon the final award and not whether it's relevant to anything subsequent to the case. And this can be found in the 2005 Exit Tribunal of Argos del Tunari and Bolivia at paragraph 25. But to that end, then, we submit that the tribunal is only required to closely examine whether the documents are actually material to the issue submitted by the relevant requesting party. And the documents are in fact not material because there is no bearing on whether there is a right to compensation, whether there is a right to claim for 35 instead of $20.67, whether the valuation of gold should be at the time of expropriation or whether it should be at the time of award, or neither does it have any bearing on the issue of whether the valuation market should be the US or Switzerland. And unless I may be of further assistance to the tribunal, this concludes my submissions.
Members of the tribunal, earlier there was a query on the time frame of the documents that were requested. Now we submit that the disclosure of documents starting from President Roosevelt is relevant, as President Roosevelt was the entity that directed the economic policies and direction of the country. Now we say that the disclosure of internal analysis leading up to the enactment of policies that the respondent state had enacted would shed light on the rationale of these policies, and therefore it is precisely this reason that this period of time is relevant to our current discussion.
Mr. Lee, sorry, I'm going to give you another minute. Can you address the last question that we had for Ms. Tan about whether or not this is your request to determine how the price was set is a live issue in arbitration?
Now, Mr. President, we say that the price setting of the gold by the respondent is a live issue, and it is relevant to two issues in our current facts, in fact. Now, there will be issues 6 and 7. Now, issue 6 turns on whether the expropriation was unlawful, therefore triggering the standard of full reparation under customary international law. Now, the requested documents are relevant and material, as they may support the claimant's contention that the expropriation was arbitrary and therefore unlawful. And this would lead the tribunal to the decision that the full standard of reparation is required. And unless I may be of further... Sorry?
You said two issues.
Then perhaps another 30 seconds. Yeah, and issue 7 then deals with whether the US market rate accurately reflects the fair market value. And we say that the current documents are also relevant because they may support the claimant's assertion that the US prices were politically manipulated, and therefore the tribunal would then apply the alternative market, which is the Swiss market standard. Now this concludes the submissions of the claimant. Thank you.
To respond to the claimant's points on the two issues that he has brought up, we submit that the request of documents is not material to those two issues, and let me further explain. For issue 6, he has submitted that is relevant to whether or not the expropriation was unlawful and hence whether the compensation should be at a higher price. However, we note that actually the subject issue in that particular issue he brought up was not whether the price was arbitrary, but whether the law of allowing us to expropriate the gold was arbitrary or not, and hence his subject matter is simply wrong. But turning to issue 7 as well, issue 7 centers around US being the appropriate market on the basis that the gold is valued relative to the currency which it is most closely connected. The US laws legislate for the gold to remain in that market, and that is why the respondent submits that the US market is the suitable market. And it's not relevant whether the price is arbitrary or not, but it goes back to whether the US law that we are basing our claims on is arbitrary or not. Since the claimant is submitting that the price is arbitrary, the request for documents is irrelevant to the determination of the other issues.
Coming back to issue 6, I thought the claimant's point was, at the end of the day, it is important to establish that it was unlawful expropriation. And surely that is somewhat related to the amount of compensation paid, which in turn must also relate to the valuation of gold, because that will in turn affect how much damages anyone needs to pay, if any. So surely the valuation of gold is still relevant in respect of issue 6, since it touches on unlawful versus lawful expropriation.
Well, we note that the law actually provides the president with his own discretion to set the prices of gold. So even though it may seem as if the prices are arbitrary, in the circumstances that the US was in, given the financial peril and the discretion given to the president, he may set his own prices, and ultimately whether these prices are reliable upon is whether the law that gives the president such powers are arbitrary or not, and not whether the price is arbitrary, because the president has the discretion to set the price as he deems fit based on his internal situation of the state.
If we take it one step further, if the president had somehow the proper powers and is properly empowered, and he sets the price of gold to be $1 million per ounce, you are saying the claimant has no claim there under issue 6? Assuming we have proof that the law that gives him that power is not arbitrary.
Well, in that present circumstances, then we agree that there might be some arbitrary conduct. However, the claim here is the disparity is too little, and they have no reliable source to substantiate their claim, and hence we submit that it is still immaterial to the issues at hand. And I conclude my submissions.
Thanks.
Are we done? Can we go home? But the rest can go home. Yes. Thanks for now AJ in Frankfurt.
They were very well.
You want break?
Yeah,
We meet your back. Unless you want.
actually, you can just leave watching here, right?
Yeah. It's the hot dog place, isn't it?
Go to where? Challenges.
Yeah.